Welcome to the Grow Your Business and Grow Your Wealth podcast with Gary Heldt. Gary is an expert in helping business owners put together a plan that will provide a better future for their businesses, themselves, and their families. On the podcast, Gary interviews other professionals who share his vision, and together they share secrets and strategies any business owner can use to build a better financial foundation for your business and your life.
Welcome back to the podcast. Today, my guest is Peter Riebling with Riebling IP. Peter has been practicing trademark and copyright for a number of years now, and he's got over 25 years, and he has managed many different projects over time. Peter, welcome.
Thank you for having me on. Very much appreciated.
So what made you get into this field?
It was actually by happenstance. You know, my wife and I had moved from California to DC, and I had done a lot of civil litigation in California. And the first job I was able to get in DC, actually, they were looking for someone to do trademark litigation. And I said, well, you know, I don't know anything about trademarks, but I know a lot about litigation. And they said, well, we'll teach you everything you need to know about trademarks. So it's kind of a interesting partnership there with the firm that brought me on. And you know, from the very beginning, right out of the box, one of the first cases that they assigned me to was a case that a trademark case that went all the way to the Supreme Court. So that was kind of interesting.
That's pretty cool for your first case to be going directly to the Supreme Court.
Yeah, kind of like going to the Super Bowl, like right out of as a newly minted NFL player, you know.
Right. So, you know, obviously you found success, you know, quite early, you know, in your career with you know, dealing with trademarks and so forth. Can you tell us, kind of give us a good story of a client that you worked on or thing that you were able to do in your career here?
Yeah, so I think one of the sort of more fun stories of my career was when a client of ours who was a software company, a very large software company, contacted us and said, hey, we've been approached by a very large computer company, and they want to buy our trademarks, and we kept saying no, and they finally brought in the big guns, and we started getting emails from Steve Jobs. The company that was courting them was Apple, obviously, and so it was interesting because I thought, wow, if they're bringing in, you know, the founder and CEO of the company, they must really want this trademark from our client. So Jobs invited us to come to the Cupertino campus in California, and so we did. And so there was 4 of us who sat down in a room. Myself, the president of our client, and Steve Jobs and his general counsel, and we sat down and started negotiating, you know, whether or not our client was willing to sell this trademark that Apple really wanted. And part of the reason that they were in such a rush was this was just a few days after Thanksgiving, and they wanted to launch a product in time for you know, being able to sell it over the Christmas holidays. And I sort of knew, you know, from a negotiating strategy, you know, in my mind, once Jobs got involved, the price just went up significantly because I knew that they were desperate.
So how long did you guys sit in the room and negotiate for?
We were there for about an hour, and you know, the president of our company, our client's company, she was very adept in these negotiations, because when Jobs was talking about how he wanted and needed this brand, her response was, well, this is one of our very first brands. We're very nostalgic about it. And then she would turn to him and say, you know what it's like to be a founder, and have one of your first company names, and you really don't want to part with it because of all the memories. And she played it really well. So we left the campus after about an hour with no deal, and I think that was smart on our part too, because we got a very good deal, a very good offer a few days later, and we accepted.
So how was it meeting him in person?
So yeah, I have to say, the one thing that I remember about that meeting was how he was very sort of quiet, wasn't loud, but he was just very calm, very rational, knew what he wanted, very confident in his like we knew, and everyone in the room knew, that ultimately he was going to get what he wanted, right? It was just a matter of what the price was going to be. And the interesting thing was, when my client and I, after the meeting, when we went out into the parking lot, we were talking, and it was, I don't know, about 4:30 p.m. And the sun was sort of setting on the Cupertino campus, and we were sort of like, debriefing the meeting, and Jobs came walking out of the building, walking to his car. And what struck me immediately was he had absolutely nothing in his hands whatsoever, other than his car keys. And I thought, wow, there's a guy who's like really organized. He's president of this giant computer company, and if it was me, I'd have a backpack, and I'd have a briefcase, and all sorts of stuff to read and everything. And he comes walking out, literally, and by the way, in the meeting, he was wearing jeans and tennis shoes, right? Like his classic, thing.
Right.
But he comes walking out of the building at 4:30 in jeans and tennis shoes, and walks to his car, says hi to us, walks to his car with literally nothing in his hands but his keys, and gets into a really nice red Ferrari, and drives off. And I thought, wow, that guy really has it going on,
Right. So when you leave the office, do you have your backpack and everything else now, or you just walk out with your keys?
I still got my backpack, unfortunately. Yeah. So, but yeah, he got his Christmas present. He got the trademark that he wanted, just in time for Christmas, and yeah. So that was a fun experience. Not all the deals are as fun as that, but that was definitely one of the funner deals.
Right. So some of the other stuff that you've done in your career, I know one of the things was whether if color may be subject to trademark protection. Tell us about that.
Yeah, so there was a split among the courts as to whether or not color could be secured and sort of locked up by a commercial enterprise, so that you could keep competitors from using color. And part of it was this idea of a color depletion theory, that there's only so many colors that a company can use for its branding, and can someone really trademark the color blue, to keep their competitors from using blue? And the answer is, in certain circumstances, yes. And this is actually the case that went all the way up to the U.S. Supreme Court. And in that particular case, it had to do with the sort of the color of a press of a pad that you could put over like when you're ironing, like at a dry cleaners. And so this particular color that they made this pad it's kind of like this, actually like sort of a green color, not really an attractive color, but the idea was that, the people who owned the dry cleaning businesses and things, when they wanted a superior high quality pad, they would remember, oh, I want to get that one that's in that particular color. And as it turns out, a lot of companies use color really strictly as a way to identify source. So sort of one of the classic examples is building insulation. So you'll see that a lot of building insulation is the color pink.
Right.
Well, there's absolutely no reason for pink to be in there. They inject that color dye in there strictly to act as a source identifier or as a branding mechanism. So people say, oh, I want that pink insulation because I've seen it before and I know that it must be good. But there's really no reason for it to be pink. You could put any other color in there. So the color pink has been registered as trade dress, which is a type of trademark you can get for product configurations or colors. And so no other competitor can use the color pink in building insulation because Dow Corning has the registration for it. So it's a high bar to get color protection. We recently obtained color protection for a retail store called David's Tea that had a certain sort of aquamarine teal type color for its storefronts. And the way we were able to do it was you have to prove to the trademark office that the color no longer is just a color, but it actually functions as a source identifier to consumers. And keep in mind that the color trademark registration is very limited to just what you're doing. So, we didn't get protection or ownership of the color teal for everything, for all goods and services. It was only for, serving tea, right? And so no one else can get that color, for serving tea, but they can certainly use it for a lot of other things, and you even get it registered for themselves for all sorts of other products and services. So, trademarks, and maybe this might be a good sort of time to talk about the difference between trademarks and copyrights and sort of the limitations and scopes of each.
Yeah, that's was definitely my next question. Understanding what if you can explain to us the difference between a trademark and a copyright, and because I know I have clients who think it's real easy to go get one of these just by saying, oh, I want to do it. So if you can explain to us the difference between the two of them and a little bit about the process.
Yeah, no. So there's really 4 types of intellectual property, and I sort of like tell people, think of them as buckets. So there's 4 buckets of intellectual property. The first would be trademarks. The second is copyrights. The third is patents, and the fourth is trade secrets. And I'll talk all about the other ones quickly, and then I'll finish with trademarks. So copyrights protect the expression of an idea. So, if you think of like a novel or a movie, or, you have this idea and, you express it, that expression is protectable by copyright. Patents protect the idea itself. So, you don't even have to make the product at all, but you have this idea, you can get ownership of that idea if you get a patent issued on it. The deal with patents is, though, you only get protection for about 17 years, and then it falls into the public domain, and that's sort of the trade-off. The government gives you a monopoly for 17 years on this idea, so no one else can even make a product that's similar. So, for example, I know someone who invented one of the early laptops, right? And so he had a patent on a laptop idea. He didn't even have to make it, but he was able to get royalties from other people who wanted to make it and wanted to use his patent. Then the trade secrets protects, you think of like the secret sauce, the recipe, the customer lists, those kinds of things. Anything that's not generally out there in the public, you can protect as a trade secret. And if, an employee, takes your customer list and goes to a competitor, things like that, you can stop them by saying, hey, you're using our trade secrets. And so then trademarks is basically anything that acts as a source identifier for whoever's behind the product. So it can be a trademark, can be a word, it can be a logo, it can be a color, and it can also be sort of like if you're a restaurant, if you had a particular decor of your restaurant, you could get protection for that as well under trade dress. And the deal with trademarks is you don't get, as I was mentioning before, with the color issue, you only get a trademark registered for the goods and services that you're actually using that trademark with. So you will not be able to get a trademark for things you're not using the product with. And so, that's why you can have, example, I'm trying to think of, let's just say, hypothetically, if you came up with a bicycle and you were selling a bicycle and you were calling it Hurricane, I could also use the trademark Hurricane on, clothing, right? Or floor cleaner or something different, right? So, so, where the fight kind of comes in with the trademark office is, well, then what really is a related good or service, right? Because the trademark office will not let you register if the goods and services are similar stat, right? So this is very, right, it's very sort of subjective and nebulous. So clearly, if you had, the mark Hurricane, I could not use the mark Hurricane for bicycles, but could I use the mark Hurricane for bicycle helmets, right? Or could I use it for bicycle tires or bicycle parts? So you sort of had this, scope of protection and that's where the fights come in. Not only would the trademark office maybe refuse my application for bike helmets, but you may sue me for using Hurricane for bike helmets, right? And so, and this is where I think, especially for people who are considering a new brand, is really make sure you do a search before you start using the brand to make sure you're not stepping on someone's toes, right? Because it's really expensive to rebrand. It's really expensive to pay someone, damages in your profits because you've been using their trademark. And there was a U.S. Supreme Court decision in March, I think, of this year that clarified that if you're using someone else's brand, you can still be liable for the damages, which is your profits that you made from the brand, even if you had no intention of violating the other prior owner's rights. So, willfulness is not an element that has to be proved for the prior trademark owner to obtain your profits for trademark infringement. So that just really, yeah.
Yeah, so examples of trademarks would be like a logo or a specific name is what you're saying.
That's right. That's right. So in our hypothetical example, the Hurricane, would be the trademark for the bike, right? And you may have a logo, artwork, right? And that could be separately trademarked. The logo could be separately trademarked.
But what you're saying is that if my name, the name of my company is Hurricane Financial, it's totally different than Hurricane Bike. So I would be okay with using Hurricane, but if my logo matched what the hurricane bike logo was, then I wouldn't be able to use that.
Well, you might be forbidden from using that under copyright, but the trademark office itself would say, well, the goods and services are different. So, you know, they probably would give you a trademark for the same logo, but you know, you would say, wait a minute, we're on the copyright to that logo, so you know, you come after me for copyright infringement. I think, you know, again, this is why a search is so important, you know, at the very beginning, because you can really save yourself a lot of money by, you know, nipping something in the bud that you might really, you know, be wed to, but realize, gosh, you know, it's just not, we're going to spend a lot more money than we need to by, you know, paying someone off.
Right.
So, you know, if I want your listeners to take anything away from this, is do a trademark search before using a brand or launching a business.
So where's the best place for them to go look to see that? You're saying to, you know, investigate it ahead of time. Where do they go do this search?
Yeah, that's a great question. So you know, the first place, you know, before they even call, you know, like a trademark lawyer, they could do their own Google search of the name to see, you know, to see what they find, you know, themselves on Google. And then, you know, then the second place they can go is the U.S. Patent and Trademark Office has a trademark search function online.
Okay.
It's a little bit clunky, and it doesn't really catch things. So, for example, if your mark was, you know, hurricane bicycles, you know, worldwide, something like that, and I just typed in hurricane, it might not necessarily catch your mark because it's very sort of, like I said, it's a little bit clunky and it's not as intelligent maybe a searching function as it should be. So we use for most of our searching, we use a private search vendor that has really good AI and it's called Clarivate Analytics. And Clarivate Analytics will do a full search. What I mean by a full search is they'll look at the U.S. Trademark Office, they'll look at state trademark offices, they'll look at the internet, you know, websites, domain names, you know, social media names, and it's about like $688 or something like that.
Okay.
A little steep, but you know, at the same time, it's what we like to say is proper due diligence. You know, if you're going to launch a company, especially if it's going to be, you know, interstate commerce, you know, it's just money well spent. You know.
So let me follow up on that question though. So a trademark, if I get a trademark here in the U.S., does that mean it's good internationally?
Gosh, that's a really good question. And the answer is no. Unfortunately, no. Trademarks are granted on a country by country basis. So, you know, if you have rights in the U.S., that just only gives you registered rights in the U.S. Someone can use your hurricane mark in the European Union or India or you know, Australia, right? And sell bicycles under those names unless you protect your trademark in those countries as well. So, and the problem is the world is becoming really more one world with you know, one jurisdiction, practically one worldwide jurisdiction with you know, online sales, right? So, you know, if you sell your bike online, you know, you're probably going to be shipping it, you know, not just in the United States and other places. So, yeah. So, and the problem is it gets very expensive, right? I mean, you're not going to file on all, you know, 88 countries around the world or however many there are. You know, you got to kind of pick your battles. So, you know, we usually tell people, you know, if you're really going to be, you know, international, you want to do U.S. and UK and EU, kind of like right out of the box, and probably Canada and Mexico too, as just sort of your baseline. you know. And if your customers are really just in the United States, then you don't really need to, you know, like you said, if you're doing financial advising and your customers are in the U.S., then, you know, you could just stick with the U.S. registration. But yeah, a lot of people think that just because they get the U.S. registration, they own it worldwide, and unfortunately, that's not the case.
Right. So, I mean, it definitely sounds like, you know, okay, the first thing that somebody needs to do, you know, kind of before they go into business or as they're going into business is really to check out to make sure that the name that they want to use or the image they want to use is not trademarked or copyrighted. What are other things that you see that are common mistakes that your clients are making before they come to you that they need you to help them get fixed?
Yeah, so I would say a lot of times, in addition to you know, the name selection and the trademark selection, there's sometimes a failure to look at whether or not the name is available on social media. So, you know, let's just say, you know, using our hypothetical example, you know, if you wanted to do hurricane for whatever it was, you know, you might get the trademark and then say, okay, now let's go get our social media, only to find out that, you know, someone, you know, has the domain name, someone has the Instagram, the Twitter, the Facebook, the LinkedIn, you know, all that stuff. So part of the whole process now, because of the way the world is and the importance of social media, is in addition to clearing the trademark, is you got to make sure you search and make sure that all those social media handles are available as well, or at least, you know, fit your pattern. Like, there are some options you can do. You could say, you know, make your Twitter handle, you know, at, you know, Hurricane Financial, or, you know, add sort of a generic, you know, word in there. But that's the other piece that I think people need to be thinking about from the very, very beginning, especially when you're coming up with the name of the company, because, you know, you want to sort of lock down all those, you know, social media rights as well. The other thing a problem we see sometimes is people using trademarks very descriptively, and thinking that they can get protection for you know, words that are somewhat, you know, descriptive. So so basically, the trademark office will not give protection or exclusive rights to that are descriptively in connection with your goods or services. So in our example, you could not get a registration for financial services or for bicycles, right? Because those are sort of the descriptive or generic terms that everyone needs to use to compete, right? So we see sometimes people, you know, come to us and they want to get a trademark registration for, you know, a product or service, but they include the descriptive word in there, the generic word. And we say, look, you're just not gonna, you're not gonna be able to get a registration for that. And frankly, I'm not sure it's good for you, you know, to be having your mark be such a generic or descriptive word in the first place. You know? Part of the whole point of branding is to stand out in the crowd, not to blend in. So we see that sometimes.
So if, you know, so I have a client who is looking to go into business, and you know, they're you know, have decided, okay, they're going to create this logo and they're going to do all this branding and stuff like that. They say that they have checked things out on the internet. They don't see that it's taken. Is that when they should come to you, or when should they come to you?
That's when they should come to us after they've done their own sort of initial due diligence on what they can do on their own. Having true to this day, I try and do as much as I can myself. And I think most business owners and entrepreneurs are sort of that way too. And I tell people, look, you know, it saves, like, you should be, anything you can be doing yourself, you should be. The last thing you want to be doing is, paying lawyers to do stuff. That's kind of my feeling. But you get to that point where it no longer is wise, and it becomes, that famous phrase, it's penny wise, pound foolish, to go forward on your own without professional guidance or coaching in an area if you're not really familiar with it. And so I would say, after they've done their own Google searching, and if they, because you can sometimes find just through a Google searching, you'll so, oh my gosh, like there's already someone out there using that. Okay, let's change, right? And you don't have to come to me to tell you something that you could find out on your own just through a Google search. But once you've kind of gotten past the Google searching point and you think it's still available, then that's when you really need to come to a trademark lawyer and say, okay, look, I need to do a real trademark search and have it analyzed by a trademark lawyer who's familiar with what the issues are and what the trademark office will accept or not accept. And the trademark office is getting really stricter than they kind of have been in the past. We had an example recently where a client filed an application for a particular mark. I'm not going to say what it was, but it was for whiskey, and it was refused by the trademark office because someone had already filed, and this is a new whiskey brand, so it hadn't been out there yet. And someone else had filed for the same mark a few years ago for coffee, and the trademark office said, well, we think that coffee and whiskey are related products, right? And so, who could have predicted that, right?
Right.
But that's sort of, and so we had to go through this whole argument in a legal brief with the trademark office to convince them that no, these are not related products. And they came back with some good evidence. They found out that some of the larger whiskey brands are now selling coffee beans. Who knew, right?
Right.
But and under the same brand, and so they'd say, well, here's four distilleries that are also selling coffee beans under the same trademark. So consumers are now expecting that people who sell coffee are also selling whiskey, or vice versa. And it took us a lot of time to sort of, unpack that and convince the trademark office otherwise. But so those are the kinds of things that can happen when you're searching. If you're searching on your own, you won't really be clued into, sort of what the trends are at the trademark office.
Yeah, 'cause I would certainly have a hard time thinking that whiskey and coffee are, considered the same. Because I certainly don't think about getting up in the morning and doing a little whiskey. It's always the coffee.
Right. That's right. Right. Yeah, one's federally regulated. The other's not. One requires you to be, age 21. The other not.
Right.
There's a lot of differences. But yeah, so that kind of, so that's just I think that's a good example of the whole battle of whether or not the goods or services are related or not.
Right.
that goes on at the trademark office.
Yeah, that's definitely one of those things where, if it's, that's a great example why someone should use a professional like you to help them, help them get through this process, because, they're not going to know that. And then if they run into it, they're definitely not going to know how to battle it. That's for sure.
And that the lesson there really for all your listeners, I think the lesson is you really got to start the process early, because in this case, the company that came to us, they had already invested and started, entering into contracts under the name, and started, making labels. And if they get, if they weren't able to get that trademark, they'd really be in a lot of boiling water, because they'd have to basically redo all their labels, redo all their contracts and all that, and it would take them another 6 months to rebrand basically. So again,
that's kind of surprising that they didn't come ahead of time, because they have to go through ATF and everybody else and get approval.
Exactly.
So that's to me is a great example of why you got to make sure that you do this early and not, not wait until after the fact. I know I have, many times I have potential clients come to me and they're already, already started doing business and everything else. They haven't been incorporated. They haven't done anything. No books set up or anything. And, oh, here, I need you to fix me. So it's definitely interesting there. What what are your challenges right now with everything? I know, when we had talked earlier, you were saying that it really seems like, business has picked up with, COVID-19 going on and everything because of the fact, people are starting to seem to be doing more business on their own and so forth. But, so what are some of the challenges that you're running into right now?
From a law firm management standpoint, I'd say one of the challenges are twofold. The first is, when COVID really hit, we started working remotely, and with the team, working from home, and I think we were pretty seamless about it because we years ago had scanned all of our client files, and we spent a lot of money scanning all of our client files so that when we needed something, we didn't actually need to go into the office. We could just pull it down from the cloud. That was really helpful. But you lose sort of the team dynamic. That's sort of important in every business, of having people in the same room.
Right.
And just sort of that energy that comes with that. And then, you don't really know what your employees are doing during the day. In most cases, they're working hard and they're working their tails off, but, you just don't know. And you just kind of have to hope that, everyone's going to, keep working hard like they always were. And we never had any issues with that. Everyone on our team works very hard. But I know other people at other firms who have sort of indicated to me, gosh, I don't really know what my people are doing, and so what we do is we have a weekly huddle, a weekly team call, and a lot of it is not even to talk about work. It's really just kind of open, free for all, just like we would be in the kitchen of the office, just kind of chatting and about what's going on with our kids and our families and that kind of stuff. It's really an effort to kind of keep the glue, among the team. And I think a lot of the glue that comes from not really so much from, the working together, but from the other stuff, talking about each other's families and our kids and that kind of stuff. So that's been helpful. And then the other unfortunate part is we've noticed just like a real dip in payment from clients, a lot slower than in the past. And you have to be sympathetic and creative with clients who are struggling. The whole world, the whole economy is struggling, and so you have to say, okay, look, we can do payment plans or things like that. But it gets tough when they need legal services, and you need to pay your employees, and you need to pay all your vendors and things, and so you can't work for free. But at the same time, we're here to. Our mission really is to help people. And so, if someone needs help, we're gonna come to the rescue, and sort of worry about, all right, well, we'll worry about paying for it later. We'll make sure that, you don't miss some deadlines or, you don't get hurt legally, and we'll try to work it out at the end. But that's been probably like the biggest business frustration, I think.
Right. So, I guess at this point, who's your ideal client right now?
Wow. Our ideal client is a client that has both a U.S. and an international presence, and may or may not have an in-house counsel. Sometimes we find that, at least for us, if a client has an in-house counsel, it's good because that in-house counsel understands the need for trademarks and has maybe been through a trademark dispute before and has realized, all right, like we don't want to be penny wise and pound foolish.
Right.
And so they understand the value of getting us involved early. And again, international is important because we have a lot of relationships with foreign law firms. So we actually get a lot of work from foreign law firms. We have clients that need, trademarks in the U.S. And so, the same sort of is true in reverse. If you were going to be, doing business overseas, we could connect you pretty quickly with like the best firms in the trademark space that we've vetted over, years of working with them. We could say, look, in this country, you want to use this, this law firm to get your trademark. They'll do right by you. So, I think that would sort of be our ideal client.
If somebody wanted to enlist your services, how do they get in touch with you?
So our website is rieblinglaw.com, RIEBLING.com. And our phone number is 202-631-2021. We are in Washington, D.C. And, be happy to talk to anyone, off the clock who just has any basic questions. We love what we do. This is what we do for a living. And so we love just, talking to business owners and, making sure that they're, kind of pointed in the right direction.
Okay, great. Thank you. So today our guest has been Peter Riebling with Riebling IP. We appreciate your time and all the knowledge that you've given us today.
Great. Thank you so much.
This show has been produced by Market Domination, LLC. To discover how you can have your own show completely done for you and turn it into a real published book and become the authority in your marketplace, go to www.marketdominationllc.com/podcast offer.